Ready? Exercise number 19, legal matter, very important matter for exam purpose. Start. In view of the foregoing discussions, we are of the considered opinion that the petitioners are not entitled for any relief as prayed for in this writ petition. No mandamus as prayed for in the writ petition can be granted in favor of the petitioners. As observed above, the petitioners are at liberty to institute a suit in a competent civil court for declaration and injunction. After taking the above view, we would have disclosed the judgment here, but certain facts have come on the record which raises some issues of public importance which cannot be ignored when relevant facts have come into the notice of the court. One of the issues which has come up in this writ petition, which was filed by the petitioners for their private rights, is an issue of public importance. That is, as to whether the land which was acquired by the state for sewage farm as early as in 1915, whether an area of 45 hectares of such land can be given by the Nagar Nigam to a development authority for construction of housing colony, frustrating the purpose of acquisition. Stop, next para. The apex court in the case of Ashok Lanka and another versus Rishi Dixit and others under bracket 2005 bracket out 5 SCC 598 held that it is well settled that even in cases when the petitioner might have moved the court in his private interest and for redressal of personal grievances, the court may, in furtherance of public interest, treat it necessary to inquire into the state of affairs of the subject of litigation in the interest of justice. Following was laid down in paragraph 42. It may not be necessary for us to consider as to whether the public interest litigation should have been entertained by the Honorable Court or not. The High Court did entertain the public interest litigation without any objection and ultimately allowed the same. Furthermore, it is well settled that even in a case where a petitioner might have moved the court in his private interest and for redressal of personal grievances, the court in furtherance of the public interest may treat it necessary to inquire into the state of affairs of the subject of litigation in the interest of justice. Double inverted comma. C. Goruer Devaswam Managing Committee versus C.K. Rajan SCC para 50 and Prahlad Singh versus Colonel Sukhdev Singh bracket out. In view of the law laid down by the apex court as noticed above, we have further proceeded to notice the issues of public importance and public interest which have arisen in this case. A division bench of this court in public interest writ petition number 4003 of 2006 reference Ganga pollution versus state of UP, in which one of us under bracket Honorable Ashok Bhushan judge bracket out was also a member, had occasion to notice the issue of sewage treatment of municipal waste generated by city of Allahabad, which is substantially flown untreated in river Ganga. In the above public interest litigation, steps pertaining to sewage treatment was considered and the court issued several directions to the state of UP, Nagar Nigam Allahabad and union government for taking steps for stopping pollution caused by throwing untreated sewage water of Allahabad city in river Ganga. It was noticed that total sewage water generated in Allahabad city is 213 MLD and the capacity of sewage treatment plant in the Allahabad was only 89 MLD per day. Thus 124 MLD of untreated sewage water is directly thrown from Allahabad city in river Ganga and river Yamuna, polluting both the rivers. The pollution in the river Ganga by throw of sewage of towns and city has reached to an alarming stage, which was noticed by the apex court as early as in 1987 while delivering judgment in MC Mehta case reported in under bracket 1987 bracket out 4 SCC 463 in following words. Water is the most important of the elements of nature. River valleys have been the cradles of civilization from the beginning of the world. Aryan civilization grew around the town and villages on the banks of the river Ganga. Varanasi, which is one of the cities on the banks of the river Ganga, is considered to be one of the oldest human settlements in the world. It is the popular belief that the river Ganga is the purifier of all, but we are now led to the situation that action has to be taken to prevent the pollution of water of the river Ganga, since we have reached a stage that any further pollution of the river water is likely to lead to a catastrophe. There are today large towns inhabited by millions of people on the banks of the river Ganga. There are also large industries on its banks, sewage of the towns and cities on the banks of the river, and the trade effluents of the factories and other industries are continuously being discharged into the river. It is the complaint of the petitioner that neither the government nor the people are giving adequate attention to stop the pollution of the river Ganga. Steps have therefore to be taken for the purpose of protecting the cleanliness of the stream in the river Ganga, which is in fact the life sustainer of a large part of the northern India. Further, in MC Mehta versus Union of India under bracket 1988 bracket out 1 SCC 471, the apex court issued direction to all municipal board for taking effective steps for stopping untreated sewage water falling in the rivers. Following are some of the directions issued to all the municipal boards in MC Mehta's case. It is no doubt that the construction of certain works has been undertaken under the Ganga Action Plan at Kanpur in order to improve the sewage system and to prevent pollution of the water in the river Ganga. But as we see from the affidavit filed on behalf of the authorities concerned in this case, the works are going on at a snail's pace. We find from the affidavits filed on behalf of the Kanpur Nagar Mahapalika that certain target dates have been fixed for the completion of the works already undertaken. We expect the authorities concerned to complete those works within the target dates mentioned in the counter affidavit and not to delay the completion of the works beyond those dates. It is, however, noticed that the Kanpur Nagar Mahapalika has not yet submitted its proposals for sewage treatment works to the state board constituted under the Water Act. The Kanpur Nagar Mahapalika should submit its proposals to the state board within 6 months from today. Full stop. Thank you very much. Guys, again I am requesting, please always try to repeat the matter, then only your fluency and accuracy will improve. And also there is one more request. If you found the matter is excellent for exam purpose, you can give your valuable comment on my YouTube channel, and also please subscribe my channel.